graduates. As an old person, when I was working for the state, I was constantly amazed by the inadequacy of the writing skills of younger state employees. It's a perennial problem. I don't know if we can fix it, but maybe it's something we need to think on, as a different project about doing what we can to address.
I'll point out here, I'm assuming I can still contribute to the conversation.
Yes, Dr. Bolus.
Yeah.
Go ahead.
There, in looking at this issue, and if you look at that section of the report, there are some other recommendations if the committee opts to want to keep the written section. It's something, and I think I pointed this out when I did the presentation, is that the weighting on the respective sections was a bit of a vestige from when this exam was worked on. When I worked on it back in 2000, the equal weighting was a bit of a subjective determination at the time, kind of in the absence of a lot of analysis, if I recall correctly. So I think there might be a table in the report that actually shows what the impact would be. And this is all in the absence of making any changes to the examination, like, for example, what you're talking about. You could potentially reweight the respective sections to reflect not the perceived importance, but the reliability on the examination. It's what we had to do when we shortened the bar examination. We knew that the written section would be less reliable. So there are potentially intermediate steps that could be taken.
But is there any, I'm sorry.
I was just going to point out also that in our current grading of bar exam questions, as well as in first year essay questions, we don't grade for grammar or spelling or punctuation. So it's not to say that in the future, if that is something that committee thinks is important, that you can't change your grading guidelines and standards to require that. But currently, we don't grade for those things.
No, but I think that is a recommendation of the Blue Ribbon Commission, which frankly, I was surprised by, but and worried about. But Dr. Bolus, is there any different weighting that could be given to the written portion that would make the overall combined results more reliable than eliminating the written portion?
Yeah, I think it was somewhere, and again, I'd have to go back and look at the report table where that was located, but I believe somewhere giving it like a 25% weighting versus a 75% weighting could achieve would kind of maximize where the overall exam reliability was located. It's very interesting because the general lay perception is a desire to weight based on the perceived importance, not the actual performance of the instrument. So people are, in many states I've discussed this with, they're loath to want to drop the weighting on the written section, but over time, they do tend to come around and understand what the implications are.
Are there any other questions or comments for discussion on this current motion? Oh, Justice, sorry, I apologize.
I just raised my hand. Yeah.
Yes.
Is there anywhere that is officially stated the purpose of the first year bar exam?
Oh, good question.
Well, the statute the statute does talk about a requirement that first year students who go to unaccredited law schools pass this exam within the first 3 administrations. In terms of any kind of language in the statute that expresses the purposes that we were able to determine, which was not a statute, but there is case law that was talked about or summarized in Roger's presentation that was made in August. So he cited, there were 2 cases that were cited. I think Bibble was one. If you want the case sites, Justice, I can provide them to you.
I guess the reason I'm asking is it seems to me that if the stated purpose, whether it's in case law or statute, is to have people take the first year bar exam to see whether or not they will end up passing the bar, and including the essay sections that we have now is not predictive of that. And in fact, keeping the essay questions in there reduces the predictive value. It seems to me it's not serving the purpose of the first year bar exam. So if that is the case, is the purpose of the first year bar exam is not to give students practice on taking essays, but it's truly to predict those students who will be able to pass the bar. So it doesn't, for example, give false hope to students who are not doing what they need to do to get to the point where they need to pass the bar. Then eliminating the essay section would further that purpose. And if that is the purpose, then I'll be voting for it.
Yeah, it's a form of consumer protection. You need to know that it's very unlikely you're going to make it all the way to bar membership and decide whether you want to continue accordingly. But
Lisa?
that may be in the legislative history, but it's rarely expressed at all, or certainly that clearly in the statutes.
Yeah, Lisa, I have the slide up.
Oh, do you want to share your screen, Roger? I can stop mine.
Yeah, if you want, but it wasn't this. I'm just saying I do have them in case anybody was interested.
Yeah, I believe there were 2 cases that I provided to you, Roger.
Yeah,
2 case citations in the in that.
one was a 1980 case versus the Committee of Bar Examiners, and one was a 85 case, Looper versus California State Bar.
Judge Reyna, you've had your hand up for a while, Judge Reyna. I apologize.
That's okay. I just put it up recently. Yeah, I had the same question in my mind as Justice Meziwala, because I also read this report and was very fascinated by it, especially when, as someone who actually likes essays, I like writing as an attorney, and I think with some of the sentiments that have been expressed, that's one of the hesitations about wanting to get rid of the essays. However, if I agree with Justice Meziwala's comments, if the point of the first year, this baby bar exam, is just to see or to give folks that consumer protection and say you should continue with law school, you're likely going to pass and you can take the ultimate bar exam, which we care about testing, I think, the legal analysis, and the essays are there. Then, and with the psychometric statistics that say that the essays aren't helping with that, then I would agree that, contrary to what I would think would be appropriate, that maybe we don't need these essays, that I would go ahead and vote for the measure. As a bar grader, I think I did bar grade at one point these first year law essays, and you go through them quick. They're usually they're good, they got them all, or they don't. You're not looking for grammar, you're looking for knowledge and substance. And if they're getting that, and if it's not there, it's not there. But if that's not the purpose of the first year bar exam, in other words, it's as the psychometrics indicate, they're not providing that predictive nature of passing, then it seems for that purpose that maybe it would be, you still focus the law schools on this final bar exam, which we very, I think, value the essays, but it's not the purpose necessarily for the first year exam, based on what the statistics are saying. So yeah, I'll just leave it with those comments. It would seem to me then I would vote for it if that's the purpose.
Thank you, Judge Reyna. Alex Lawrence, I see your hand up.
Thanks, Mr. Chair. This just reminds me, I'm coming from a sort of a different angle, graduate business school education, and currently the new format of a standardized test is eliminating the writing component. As it states today, there is a writing component. It requires the candidate to, it involves an analysis of an argument as well as an analysis of an issue. And many of the schools, including UCLA, did appreciate that part of the testing, because just knowing from a balance of somebody from a quantitative versus a sort of a verbal side of skills and ability, it did give, through many schools doing their own independent research, somebody's ability to handle, say, the workload. Again, this is a graduate business school, and the fact that they've the new format is going to be removing this writing component. There is a lot of concern by the schools to have some kind of a writing element. And so it seems like it's kind of coming back. So I'm just kind of throwing that out there as just sort of like when I was thinking about this part about getting rid of the writing, again, on the graduate management education side, a little bit further along than where we are right now, but probably would, if it currently stated the motion, I would be voting against it as well.
Are there any additional comments from our?
Just one more
Yeah.
question. So do we know what the purpose is? I know we're all speculating here. I still haven't seen a statute or exactly what those cases actually say. Do we know what the purpose is sitting here?
Alex,
Because
I can,
otherwise-
sorry, I can speak to that quickly for you. I pulled up the cases that Lisa and Dr. Bullis were talking about, and the one on point is, I can never pronounce this correctly, Bibley versus Committee of Bar Examiners, which is a 1980 case in which a plaintiff challenged the first-year law students exam. And the court, the California Supreme Court, articulated the purposes as follows, and I'll just read you a direct quote so that you have it. There is a strong public policy in the requirement of the first-year law students exam. It serves a dual purpose of protecting persons who are ill-suited for a legal career from continuing to spend time, money, and effort following completion of a one-year study in an effort that has little chance of success. And it affords persons who are better qualified for a legal career an opportunity to measure the quality of their training and education after the first-year study to better prepare themselves for the general bar exam. So that's the purpose as stated in the case law by the California Supreme Court. A purpose is not set forth in the statute, just to be clear.
Very helpful. And given this case, if the committee does decide to move in one direction, do we need the Supreme Court to, or the Board of Trustees to stamp this motion and say it's okay? Or can we just move without any insight from the Board of Trustees or the Supreme Court?
So the Supreme, go ahead, Donna, I saw you unmute.
So this is a decision that is within the power of the Committee of Bar Examiners. There is a rule, is a rule that I think Lisa cites too in the agenda item, which specifically delegates to the Committee of Bar Examiners from the board the authority to determine the format, scope, content, words to that nature of the first-year law students exam.
Thanks, Donna.
Right. Any additional comments or discussion on this motion?
So
I don't.
I'll put the motion back up, sorry.
Okay.
Thanks, Lisa.
This is Kareem. I'll make the motion, Mr. Chair.
Oh, I think we haven't moved and seconded.
Yeah, we already had an initial motion by Paul and then second by Alan, I think.
I'm gonna third it
So-
then, if that's
Okay,
within the
sounds
rules.
great.
Rosenberg rule. Sorry about
All right,
that, Dr. Cal.
No problem, sir. So we will go ahead and do a roll call vote, Devin, for the motion that is currently on the screen.
Dr. Bolton,
No.
Robert Brody,
Yeah, I'm sorry, I'm gonna have to vote no as well.
Alex Chan,
I'll have all my colleagues, but with regrets, no for me.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Paul Kramer,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence,
No.
Esther Lynn,
No.
Justice Macy Walla,
Yes.
Bethany Peak,
No.
Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
You're muted, Vince.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Dr. Cow,
No.
with 9 yeses and 7 nos, the motion passes.
Thank you, Devin. So
What
this
about
conclude,
what about
Go ahead, Al.
revisiting the cut score? Is that something we should just put on the work plan or?
Yes. Yeah, talk about it in the work plan.
Okay, so we'll, because it sounds like we're due. You don't need a motion for that.
No.
thank you, Paul. All right, this concludes the agenda item. And then it looks like it's 12:37 right now. So if it's okay with everyone, we would take a 30-minute lunch. And then I guess we would come back at 1:07 p.m.
And we'll return and open. I know for the new members, I sent out just a placeholder close link. Don't pay attention to the time of that. We're going to return and open back with the eligibility item.
Okay, great. All right, everyone grab some lunch. We'll see you back in 30 minutes. Thank you. All right. Hello, everyone. I hope everyone got a chance to grab a lunch, or just when you're eating, you can turn off your screen if you're eating to finish your lunch. So apologize that we had 30 minutes for lunch, but we still have a lot of items on the agenda to get through. So, all right. So I see everyone coming back on screen, so we'll wait 1 or 2 more minutes to let everyone go ahead and join in. But just to remind everyone that we were previously talking about agenda item number 4B, which is what Donna and Paul and Ashley and Audrey were working on. And I apologize, we had to interrupt that presentation because we had to get to the special session with Dr. Bolus because that was his only availability. So that's what we'll be starting out as. So Devin, do we have most people? Do you see most people back on before we start?
It looks like we do.
Okay, do we need to take a roll call, Devin, or we can just go ahead and start with the continued presentation?
We can resume the meeting, no roll call.
Okay, thank you, Devin. Okay, so we'll go ahead for everyone that we will going back to agenda item 4B, and I will turn it back over to
me.
to Audrey.
To me.
Thank you, Audrey.
No problem. So I believe we've concluded this slide on the 5-year expiration of the passing bar exam score. Are there any other? I just want to make sure. I'm going to look at the panelists. Any other hands on this before I move on? I don't think so. Great. Okay. So I'm gonna try, I believe I have about 8 more slides to go, but I believe these will go more quickly. We've covered some of this before. So this is Rule 4.26, which is about legal education and eligibility for the bar exam. And then there's this new 4.29.5 related to law office study in terms of similar parameters. So the state bar rules largely mirror the language in 6060. Qualifying for the bar exam by a JD from an ABA school or a California accredited school, or 4 years of studying law diligently in good faith at whatever unaccredited schools or through law office study. So the working group and the staff talked a lot about studied law diligently in good faith, and in terms of that being ambiguous, for the applicant and for our staff to make these determinations for eligibility for those folks who are not going the path with the JD from an ABA school or a California accredited school. So what we've landed on here and what was in the attachment for you to review is putting these additional sort of parameters, definition about what does it mean to study law diligently in good faith. So for the unaccredited school study, I just cut and pasted here because I wanted to make sure you all saw the language that was in the revised rules. So to demonstrate that the study was diligent and in good faith, the applicant must show at least 4 years in which they made sufficient academic progress to proceed to the next year in law school where the study occurred, or that they were in good academic standing as defined according to the law school's policies, guidelines, or regulations. So this language gives a lot more shape to what it means to study law diligently and good faith. On the law office study side, requiring the supervising attorney or judge to attest that the applicant that they are reviewing is demonstrating sufficient academic progress to continue to the next 6-month study period so that they're able to progress, sort of similar in intention to the bullet point above. Are there any questions? Okay, and if I miss one, Devin, let me know since I'm sharing my screen. Okay, well, we've talked a lot about the first year law students examination today, the structure of the exam, but Rule 455 is written in terms of who is exempt from taking the exam. So you have to take the exam unless you are exempt. That's the way that the rule is written. One of the ways to be exempt is if you complete 2 years of college work and the first year is at a California accredited or ABA approved law school. So the rule states now that you can only be exempt if the school has advanced you to the second year of instruction, but the eligibility team's experience is that applicants who were academically dismissed from their ABA school or California accredited school believe they're still exempt. So, or maybe they haven't even finished the year, or they were dismissed at some point between the beginning and the end of that first year. So to clarify, we have added that the full first year of instruction was from an ABA or Cal accredited school. So the word full there in that first bullet point. Also in this rule revision is to take what's in the statute already, which provides an exemption from the first year exam when an applicant has passed the bar exam of a sister state or of a country in which the common law of England constitutes the basis of jurisprudence. So that's just to make the rule match the statute. And then a legislative proposal that was actually approved 20 years ago by the Committee of Bar Examiners to amend the statute to provide a stay of the eligible attempts for that first year exam if someone is called to active US is how we've amended it thanks to the working group's input this past week, active US military duty. Those are some of the highest and best points from these revisions. All right, well, stop me if you want to stop me. I had a soda, so I'm going to be talking even more quickly. Okay, 4.25, general education. This one's 10 years passed from the Committee of Bar Examiners. So 10 years ago, the committee looked at applicants who wanted to look at their 2 years of college work as being graduate level coursework. So depending on where your degree might be from, different countries, different schools might allow you to have graduate level coursework in your, what we would think of as an undergraduate degree period. So the committee back in 2013 amended this to say that 2 years of graduate level coursework verified by a committee approved evaluation service can meet the 2 year of college work stipulation in the statute. Okay.
Audrey?
Yeah.
On the
Yes.
general procedure of that, so the committee took some kind of action, but didn't actually amend it into the rules.
Yeah, it went, yes, and then that's our history, like look back, and all of us did this as part of the rule revision. And looking back, yes, the committee was approved this change, but it didn't get forwarded and changed in the statute.
So it didn't
Or made
implement
forward
it, in
change.
effect. Yeah.
Yeah.
So
It was approved as
I
a
hope we all
policy.
agree. I hope we all agree that that's not the right way to do things going forward.
Yeah, and that's why we went through this exercise, right? There were a lot of things that the committee approved as policies that that staff may or may not have been implementing since that time, but that didn't get amended into the rules. And so we went through, as Audrey said, we went through the last 20 plus years of committee agendas to see everything that the committee approved to make sure that each working group that was looking at these rules would consider all those policies or guidelines as well as the rules to determine what should be in the rules. So we didn't have these outlying policies that nobody knew where they were, whether they be staff or applicants.
Yeah, our goal being to put things in the rules so people can look to one or two. We'll have an example of that later. Places to know what the rules are rather than obscure minutes of a past meeting of the committee, which aren't really even available to the public.
No, exactly. I mean, so people don't have to intuit what things mean, and that things that were intended from, you know, this committee before are actually codified.
Good work.
Well, you helped a lot, so good work to you. Rule 4.27, so unaccredited law school study. Right now in this rule, the credit calculation is a one-year calculation, but our eligibility team, in terms of looking at eligibility to sit for the bar exam, it advantages the applicant to be able to look at 6 months and in addition to the 1 year. We also have minor change. There's a definition of 1 year in the definition section, 4.3, and that's going to be moved over here where it makes more sense thematically to be here about what 1 year is. And then addition of distance learning, a modality that the State Bar has recognized, in addition to correspondence, the way that it's written in the rule currently.
So on that one, you don't get credit for law study unless you complete it either in a 6-month or a 1 year interval.
Right. And right now it just says 1 year.
Right. So this is an improvement.
Yes.
A concern of mine is, while I think it's very good not to let people go through their studies too fast. In other words, to complete 2 years of work in 1 year, I would think, you know, that's short changing their, you know, their their ability to absorb the material and do a good job of study. But I don't see the reason why we can't let somebody complete, say, 1 year's work, for example, in a year and a half or 2 years and get credit for it. And the current rule clearly prohibits that. You lose all the credit for all the effort you made in those 2 years. This at least allows you to maybe do things in 6 months chunks. But what I'm going to propose for the work plan is that as a later effort, we consider whether we need to be so prescriptive about the time in which people must complete the work, and perhaps allow them to do 1 year's worth of study in 2 years. Unless there's some reason, there may be some practical reasons and administrative reasons not to do that, but I don't propose to hold up this effort for that. But I would like to see us think about whether we can be more accommodating of people's, ability to devote time to their studies.
So in 2004, so not quite 20 years, the committee adopted a policy that allowed law students to start their first year over. That policy is on a form. That form is on the website, but it's not in the rules. So this is proposing to have what we call now the start over form as part of the rules. So students who start over won't receive any credit for any law study completed prior to starting over, which is how the policy is now. The working group talked at length about whether we should allow this student practice to continue, but in the end concluded that students should be able to, given that all the schools are required to have their disclosures, they should be able to, if they want to, start over their law school studies. So that's codified in new rule 4.28. So evaluation of study completed or contemplated, this is asked of our eligibility teams all the time. So because people will come and ask for their what they've taken in various different modalities or different universities to evaluate that, or they'll say I'm thinking about taking these courses, can you evaluate this? So these are requests that come to the team all the time, but this rule proposal is to really streamline it and to set some more parameters around it so applicants know how much time the process will take. And then it also recommends a process for additional committee review if the eligibility team gives the applicant an answer about their law study and what it may or may not count for in terms of the first year exam or the bar exam, and they want to appeal that. It gives that process in writing in this rule set. Okay, so the guideline is foreign educated and foreign barred applicants. The guidelines, we have a guideline now, a committee guideline for foreign educated general applicants who have a first degree in law, and that guideline, the proposal is to put that guideline actually in the rules with a minor change. Right now, the guideline talks about those students taking these courses in an LLM program, but a minor change that could remove a barrier for some is that the same courses, the same requirements can be taken non-degree seeking. They do not have to be in an LLM degree. Also, a committee policy allowing applicants with refugee status to petition for a waiver of documents required for registration as a foreign educated law student or for licensed bar applicant is in this proposal. And then, sorry, this is sort of small on the slide, but I wanted to make sure that we had this in here. In 2013, so another 10-year committee policy proposal, applicants were required to submit, and they still are required to submit, a certificate of admission or certificate of good standing from the primary or highest professional bar admissions regulation attorney licensing authority in their jurisdiction. The final guideline didn't have that exact language about the highest professional bar admission regulation or licensing authority, but in practice, that spirit of how the eligibility team evaluates those requirements is still how staff looks at the foreign attorney licensure. So because that was the intention of that proposal in 2013 and how the eligibility team still looks at these requirements. We are proposing, and the working group and discussion proposing to put this into the rules about have that certificate of admission or certificate of good standing, and that was issued by the highest professional bar admission regulation or licensing authority in that jurisdiction, and that they could practice law without restriction. So again, reading through statute, our admissions rules and the California Rule of Court, making sure that different places that reference similar things have similar language. This is a recommendation from Paul as part of the working group to match a suggested change to 6060 to make sure that when we refer to the examining committee, we also refer to or approved by the American Bar Association. So that's to match the language about what is deemed accredited by the Committee of Bar Examiners. So California accredited and approved by the American Bar Association. So you'll see there's a new attachment this week to make sure that that matches the other proposed language in 6060. And then similarly to add in distance learning, where that California Rule of Court refers to correspondence. Okay, so I went through my slides pretty quickly. Do we have any questions? I will look at the squares.
You didn't mention the changes to B&P code 6060.
In
Which we
terms
are
of the
also-
specific changes,
Well,
about
we're recommending similar changes to mention
Yes.
the ABA, and there were a couple others, I think. I don't know if they were of significance to highlight before the group. Let me take a look, but. And
Yeah, sorry.
the thing about that mention of the ABA was, we all know that ABA students don't have to take the first year law students exam. But when you go to try to find that, the authority for that, the current business and professions code simply talks about schools accredited by the committee or the examining committee, I think we're called in that section, and doesn't mention the ABA. To understand that the ABA schools are also covered, you have to go into our accredited law school rules, where there's in essence, just a statement that ABA schools are deemed accredited by the state bar, and that to me that's just not really good and clear drafting of rules and regulations, because you shouldn't have to go to multiple places and know that this little obscure provision exists in order to form a complete picture of what our requirements are. So it's simply a clarifying amendment to make it easier for the reader, and as the courts would say, or the legislature would say, declarative of existing requirements, not something new. But let's see. So in 6060, I'm looking at the amendments.
I have it on the screen in terms of where that language about or approved by the American Bar Association.
And
This is
and Natalie would tell, I don't know if it's worth making an additional improvement to that, but Natalie, when we were working on the accredited rules, told me that the ABA is very insistent that they don't approve the schools, but I forget the name of the term, council on something or other is actually their sub-entity that does that. So I wonder if we want to, and that's the term, the council or whatever, that we used in the accredited rules. I wonder if we don't want to go that far here.
on their the website at the ABA lists the ABA approved schools. And I think that's how, so maybe that. there's a footnote.
Okay, then that's good enough. But
Yeah.
I know Natalie was very insistent that they were very insistent when we called it something more precise in the accredited rules that we adopted a couple of years ago. But I can.
The ABA definitely doesn't use the word accredited. They use approved, but yeah, thank you.
Yeah.
is there anything else from 6060 would you like me to highlight in terms of the changes? One, and I put this in the item, one small thing is to add a date to the LLB degree. So the US law schools haven't given LLB degrees since the early 1970s. So this will come back to the committee if it gets approved to be a change in the statute. Because there are many undergraduate institutions that now do Bachelor of Arts in law. So we don't want there to be confusion in terms of a JD and a bachelor's degree. So.
Yeah, and then we took back out the additional opportunity to take the first year exam. I think it was, yeah.
Right.
That was operative during COVID, but no longer
Yeah, the
applies.
pandemic related fourth attempt is no longer in the statute. Or
Okay.
it was recommended already to no longer be in the statute.
Yeah, that was that was updated in this year's fee bill. So when that and that was signed by the governor. So when that takes effect, that provision will no longer be in the statute.
They still have
So-
the three givings of the exam in there though, right?
Yeah, the original.
The only
Okay.
thing that was changed was elimination of that fourth attempt, because it's by its own terms, it wouldn't apply to anybody anymore.
Right, that the opportunity is passed.
Do you have any other comments on this item? Or should we open it up to the rest of the CB for any questions or comments?
Yeah, go ahead with that.
Okay, are there any comments from our fellow CB committee members?
Justice Mesiwala.
Justice?
Hi there. I just wanted to go back to the discussion about the word full. I think it was in one of the first slides.
Yeah.
When we talk about full, do we mean that that first year course of study has to be completed at that law school?
Yes.
Would it be better than to use the word complete?
Yeah, we actually had this conversation.
Okay.
No. I appreciate it. I'm trying to find it and I think because there was like a word complete was right before.
Yeah, it's to complete a complete year. It just it felt awkward.
Yeah.
And so we landed on full as the sort of best term, but we're certainly open to other options.
So it says to complete a full term. So the idea of complete is already in there. So it wouldn't make any sense to say to complete a complete term.
Right, exactly.
Okay, got it. Thank you.
Any other comments or questions? All right, seeing none, I'm going to ask the call for a motion.
Okay, and Donna and I have been trying to work behind the scenes with some of the conversation from earlier today. So I had the motion obviously in the posted agenda, but I have some revisions that are underlined here, talking about the revision we made to the 5-year bar exam passing extension. What I added later this week, sort of just a clarifying the ABA approved and then adding distance learning into the California Rule of Court 9.30. And then the conversation we had at length this morning about the certification of the Supreme Court related to child and family support arrears.
So just to clarify, Audrey, so based on this morning's conversation, these are the amendments to the original motion that we had all received and looked over before today's meeting. Okay, just wanted to clarify that with everyone on the committee. So this is our motion. May we have a first on this motion?
Wait, can I just get a little clarification, Audrey? I'm sorry, I've lost the thread. What is it that we're saying about the outstanding child support obligation?
I can take that. So what is in attachment A is the version that that would continue our current practice, but just clean up the language such that assuming we get the legislative authority along with it, that we would continue to not provide a temporary license. The alternate version, because we are going to be pursuing, the recommendation here is to pursue a legislative change along with it. If we get an indication that a legislative change is not appropriate, then obviously a part of our entire intention here was to make sure that the statute and the rules and the practices are aligned. So if the legislature isn't going to make that change to 17,520, then our rules should align with the current statute. And so the alternate version just strikes out that reference to if you're delinquent in child or family support, then you can't get certified to the court. So it strikes that out as one of the elements that's required, because that would be consistent if that's the direction that the legislature chooses to go in. So we would put out for comment, right, the alternate versions. One if the legislature enacts the changes that the committee is recommending to 17,520, and this version if they don't.
And this is that
Wait a
alternate version.
minute.
So if we vote no, then we will not require that there be no outstanding child support obligation.
See, I don't think we can do this way.
Trying to figure out what is yes and what is.
I wonder if there's a way to decide before we finalize the package whether or not we want to continue to see the family support order rule applied to persons initially becoming members of the bar.
We can take a separate motion on that first, and then based on the outcome of that, tweak this motion.
Yeah, I think that would be
Yes,
easier.
I think that's better. I think that's better because personally, I'm not in agreement with that, but I'm in agreement with other parts of this motion. So I would prefer to break it down.
May I propose some language, Robbie?
Yes.
Move that the Committee of Bar Examiners approves the changes in Rule 4.15, sorry, related to child and family support obligations.
So
or move that they don't approve it, whichever way you'd like to word that.
well, the way you've written it now, a yes vote would mean barring an applicant from proceeding if there is an outstanding child support obligation.
Yes, assuming the legislative change also goes through.
How about phrasing it in terms of a policy? So the Committee of Bar Examiners desires to exempt the admission of new attorneys from the requirements in the in Family Code section 17,520 that a temporary license be issued and instead deny admission until the obligations are satisfied. Is that clear? Because that's the current practice apparently. Right, Donna?
Yes, the current practice is they are not certified to the Supreme Court if they are on the certified list that we get
so-
from the Department of Child Support Services.
And in order for us to be able to do that and be consistent with the law has to change to say that that's okay.
Right.
So I'll make that motion. And we're
Yeah.
basically taking the pulse of the committee at this point.
So if I may ask Paul and Robbie, does that align to what your intention was
Well,
for the family support, Robbie?
well, based on our, healthy discussion today, including, my own feelings, I don't want an outstanding child support obligation to bar an applicant. So I think the way, Paul, you phrased it, then if that's the way you feel, then you would be voting no.
Or you would be.
I would be voting no, right?
Yeah.
Because of the things that we talked about, that there may be other circumstances that prevent being in compliance with a child support order that are unrelated to moral character or fitness for the bar. So I would be voting no for that. And yes, if you want to take the temperature of the CBE on that issue, so we don't junk up the other provisions that Donna and Audrey have explained that I do support. It's just this one that I have an issue with. I don't know if nobody else on the CBE feels that way too, then
No, I'm with you, Robbie. This is Bethany.
Yeah, and actually I'm a bit in the middle. Philosophically, I'm opposed to what I described earlier as blackmail. But the problem of, somebody starting out and then in 150 days having to be suspended convinces me that maybe the better approach is to just not let them start until they solve this problem.
Well, I'll just say again, nobody likes to hear about a deadbeat dad, but that may not always be the case with respect to outstanding child support obligations. I have seen many other reasons that go to, poverty, inability, disability, that may prevent someone from meeting that obligation.
Yeah, and I certainly understand that, but the family code doesn't seem to allow for those determinations. And I really wonder, given the few cases that we're likely to encounter, if we want to insert the state bar into this whole question and system. It's
I feel like we're more staying out of it than staying in it if we don't make it a requirement here, where we're not the family court. The family court will address that, whether it's garnishing wages or whatever they want to do to enforce that. But I don't feel like we, particularly, and I think Bethany and others brought this up, this is going to be your ability to obtain work, perform work, and maybe satisfy that obligation.
Hey, Robbie, what is, I don't know if there are rules in place already. If not, maybe this is something for us to consider, which is to provide for an exemption request option where they could potentially submit an exemption request for us to consider.
Well, I think we may do that in the context of a moral character application, but honestly, I don't want to create more paperwork and things for a bar with limited resources. That I'd like to see the resources put in other areas and just stay out of this entirely. If you want to apply to sit for the bar exam and be admitted, moral character is one thing, but I don't think we should bar you from applying because of an outstanding child support obligation.
But then we also suspend existing attorneys if they show up on the list. do the same arguments that you're making in against preventing their admission also apply against suspending them later when they show up on the list?
Is that true, Donna? We suspend practicing attorneys?
We do, but I think what I hear Robbie and Bethany arguing for is treating initial admission the same way we treat licensed attorneys, i.e. if you are a licensed attorney, you get a 150-day temporary license because we give you notice that you are on the list, and if you're not off the list within 150 days, you will be suspended. In the same way, here, if we eliminate the requirement in 4.15, 4.17, if we eliminate this requirement, we change our current practice, then we would similarly be issuing a 150-day temporary license, which would then be suspended until if they were still out of compliance.
I don't know.
So that's our option.
I'm hearing them say that they don't like the idea in general that an attorney's ability to practice would be affected by outstanding obligations.
Yeah, you know, I'm sorry, honestly, I didn't know that resulted in an automatic suspension. And I'm sorry if we've talked about that before. I guess just because I've seen the other side of that issue. Well, Bethany, I suppose 150 days notice to do that is better than nothing.
It's
So
better
may-
than nothing. And I'll just say for the record, I oppose this practice generally across the board statewide, but this is the better of the two options, I think, in my opinion.
This
May-
being to give them the
Temporary
The
license.
provisional license, yes, I agree. You know, I think this has a disparate effect on lower income people who may not have had the judicial resources to fight a child support claim. And gosh, there are just a zillion variables that, you know, and maybe the majority of them are bad guys or gals that are not paying their obligation, but it's certainly not all. And, you know, I oppose it in principle too, but if that's what it is, Donna and Paul, then I agree with Bethany that the temporary one, and maybe that will spur any applicant who now is, you know, seeking to become a member of the bar to either file something with the DA's office or pay it or borrow it or something. That's almost 6 months. So that's a lot of time to get that resolved and get either off the list or not. So
it's actually, 5 months, I think.
how does that change what? Okay, so this motion,
Well, you're desiring, it sounds like, or you're suggesting we amend our rules to comply with, to be consistent with Family Code 17520.
Yes, that is what Robbie and Bethany are suggesting.
Okay, so move that we desire to amend our rules to comply with family.
Well, may I call on Justice Mesiwala? She's had her hand up.
Sure.
I had my hand up, but I lowered it, and maybe I shouldn't have lowered it. I still don't, and maybe the motion is changing so I can better understand it. I'm just not sure what a yes or no vote means. So maybe I need to read this as it's changed. I'm generally in agreement with what Robbie and Bethany are saying. So I want to make sure I understand that where this motion aligns with what they've been saying.
Yes, so now the motion as written, I think it's clearer now. The motion would be, Robbie and Bethany would be a yes on this motion based on everything that I've heard them say, right? So the idea here would be to amend the rule such that being being on the certified list of delinquent obligors is no longer one of the elements that would prevent you from being certified to the Supreme Court.
Yes, that is much clearer. Thank you.
Yes, thanks tons. So I'll make that motion.
I'll second it, James Bolton.
Thank you, Dr. Bolton.
Okay, so I just want to make sure to clarify. So we're going to do two separate
Yeah.
motions. So the first motion, number one, Robbie was first and Dr. Bolton is the second. All right. Is there any more discussion on this first motion? If there is not, we'll then call for a vote on the first motion. Are there any comments or questions for the first motion? Okay, Devin, can you call for a vote on the first motion that Robbie proposed and then Dr. Bolton second the motion?
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Alex Chan,
Yes.
Jim Epting,
Yes.
Kareem Gangora,
Can you come back to me, please?
sure. Paul Kramer,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence,
Yes.
Esther Lynn, Justice Macy-Walla,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Dr. Cow,
Yes.
back to Kareem,
Yes.
Esther Lynn. With 15 yeses and 0 nos, the motion passes.
Right, so motion one has passed 15-0. Now, motion two is what is on the screen based on the comments from this morning. So is there anyone willing to make a motion for item number two?
Dr. Cal, one quick change before you do that.
Yes, ma'am.
Audrey, if you would strike out Family Code Section 520. Because now we're not seeking to change the statute, we're seeking to align our rules with the statute. And strike out the "and" also after that. And then whichever is the right attachment, which applies to 7660, is the only attachment that should be referenced.
That was attachment D was 1520, so strike that one. D is in dog.
Strike D. The way I have it.
Yes. Thank you, Dr. Cow. I apologize for interrupting.
No problem. So that clarifies it then, Donna?
Yes.
Okay, thank you so much. Okay, so the motion two as what is on the screen. If there is anyone that would like to make a motion for that.
Can somebody remind me what the revisions to 4.17 were?
I will show it on the screen. 1 second.
I'm sorry, I have forgotten to.
Yeah, I don't recall that we made any.
Yeah.
I was typing it in at the time. Let me show it. 1 second.
Yeah, I apologize for breaking our thread of our discussion this morning with that. So I'm sorry about that.
No, I think it's working fine.
It's the addition of E.
Oh, yes. Okay, yes, thank you. We added a deadline to file the request for an extension.
So, Donna, to be clear, I guess this is our patch-up attempt after we went down in flames with the Board of Trustees on the idea of waiving the 5-year rule.
Well, it was the court, but
Yeah.
Right, the court, yes. I mean, that did pass by a very slim margin at the CBE, but so this is our next stab at shaping it up as best as we can.
Exactly.
Well, yeah, the court would certainly be happy with this.
Should we put the motion
We're
back?
good.
I will
Oh,
make this motion. Of course, I'm the person that made the motion, because I think, Don, I was on this subcommittee with you. I was the person that made the motion. That's the opposite of what's on the screen. But given that the court has rejected that, I suppose this is a little bit of some guidance that the bar can use. So I'll make this motion.
Thank you, Robbie. Is there a second?
This is Bethany. I'll second.
Thank you, Bethany. Let's open it up for discussion on this second motion. Are there any comments or questions from the committee for motion number 2?
No.
Okay, seeing that there's no hands raised up, let's go ahead and take a vote, Devin.
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Paul Kramer,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence,
Yes.
Esther Lynn, Judge Macy Walla,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Dr. Cow.
Yes.
With 15 yeses and 0 nos, the motion passes.
Okay, thank you, Devin. So we will move on to our next open agenda item, which is agenda item number 5, Ed Standards. I'm going to turn over to you, Natalie and Jim, for that. If that's okay.
Sure, thank you. Jim, would you like me to start?
Yes, please.
Terrific. Okay, under Rosenberg's rules, I'm going to ask Viviana to open the presentation and start with the motion. The first motion is for Taft Law School. Taft Law School is an unaccredited correspondence law school located in Santa Ana. They filed a motion to move their administrative headquarters. It was a very complete and clear motion, and they very willingly responded to staff questions as well. They've been in their current location for quite a bit of time. They're in an office complex right now, but they started to experience habitability issues in that office complex. Also, their chancellor passed away and their prior longtime dean retired, and they like the idea of starting in a new space, fresh with their newer team. Also, the new space is better appointed and less costly than the current space that they're in, and it's very nearby. So they've requested permission to move as of November 1st. It's unusual that a school would move during a semester, but this school is completely in correspondence mode, and all of their services are remote. Therefore, a physical move will not affect what they're doing, and their student support services are all online in an online learning management system, so they don't expect any disruption as to the students. The motion suggests that the move should be approved, and it should be approved November 1st. Their current lease expires October 31st, and this will allow for seamless transition. Are there any, and I believe that Dean Jolly is also here. If she would like to make a public comment of up to 5 minutes. Welcome, Dean Jolly. And so if we could recognize Melody Jolly, please.
He's been given the mic.
Thank you. And Dean Jolly, I think you just need to unmute.
Thank you. Can you guys hear me loud and clear?
Yes.
Great, thank you. I just want to thank you for taking this time to hear our motion. It's something that we're looking forward to get a fresh start. We've had so many issues for the last 2 years with no heat, and my poor employees are coming in with parkas and their little gloves and their hats, And then we've experienced the summer with no air conditioning. And as you know, it's been extremely hot. And then we've had an infestation of cockroaches. So people on this end are kind of upset. We've tried to negotiate with the landlord. It's a new landlord. He's taken over in the last 3 years and we just don't get service. So that's why we decided, you know what, this is our opportunity to get a fresh start since our lease is coming to an end. And we will have an elevator. When we had DAC come out for an inspection and they didn't like that our old building did not have an elevator. So that should make those accreditors happy because we will have an elevator. We're actually going to move across the street to the Cave Wave building. So it's been in existence for over 30 years. It is a high rise. It's 6 stories and we'll be on the 3rd floor. And we have great undercover parking as well as above ground parking. And so we're hoping you will approve our motion because we are looking forward to the change. Thank you.
Thank you, Dean Jolly. I would say it's also very helpful. The space that they're choosing is smaller than the space that they have, and they very carefully explained why and why this will still be adequate for their needs. And it's primarily related to the fact that they previously had physical files that they've now digitized. So the new space, even though smaller, should be fully adequate to continue their operations as they have done.
Hello, hey, this is Robbie. I'm curious, Dean Jolly or Natalie, how many students does your school have? You're muted, Dean Jolly.
Sorry. So approximately for Taft Law School, we have about 240 students.
Wow, and they're all remote for
All remote.
everything?
We've been always a correspondence school. So in the olden days when David Boyd started the school, it was all by mail. And then when the internet came along, obviously we moved to online. And we actually obviously will have no interruption. We never have because everything obviously is hosted online.
But is it async or are there real live classes or?
No, we have no live classes whatsoever.
Oh, so you mean they're pre-recorded and students listen to them and then get their assignments that way?
So we actually have a syllabus that students follow, and we do have lectures that they can listen to at any time that are pre-recorded, yes.
So you just use the same lectures for that class each time that class is offered?
Correct.
Oh, wow. Okay, thank you. I'm just not familiar with that format. Oh, okay, thanks.
Thank you.
Are there any questions or comments for Natalie and Jim concerning this motion? Okay, seeing none, may we have the motion up, and is there someone willing to make that motion?
I'll make the motion. This is Kareem.
Kareem, thank you for the motion.
Jim
Is there a
Afton will second.
Jim, thank you for the second. Are there any discussions about this motion from the committee?
Quick discussion, Dr. Cow. Is there any way we can move these things to the consent as well, or is that not permissible?
Let me ask Audrey.
If there was no need for discussion, then I think we could move it to consent, and a member can always pull it off.
Yeah, that's what I was thinking.
Yeah,
Okay.
this is our first meeting experimenting with a consent calendar. So thanks, Kareem.
That's a great point, Kareem. Thank you. So seeing that there is no discussion on this first motion, Devin, can you call for a vote?
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Paul Kramer,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence,
Yes.
Esther Lynn, Justice Macy Walla,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson, Alan Yokelson,
Yes.
thank you. Dr. Cow,
Yes.
With 15 yeses and 0 nos, the motion passes.
Thank you, Devin. Natalie, could you go on to the next item?
Yes, I'll ask Viviana to move to the next slide, VB, regarding American International School of Law. So for the benefit of new members joining us for the first time today, in August, the committee reviewed the inspection report of American International School of Law, and after reviewing it, adopted a large slate of recommendations and issued a warning letter to the school to take action to address each of those recommendations no later than November 15. The school reviewed those and set a meeting with staff, discussed them, and then determined that it would voluntarily terminate its registration and close. It submitted that in writing. It's requested permission to stay in operation through November 15th. Reason being they have 2 students that will be able to graduate by that time, and there are no additional students. Over the course of this year, after the inspection, the school closed admissions, did not accept new students, and made this plan to get almost every student to graduation. One final student would not be able to finish by that time, and she has agreed to withdraw. The State Bar has reached out to her to provide her with responses to any questions that she may have. So the motion suggests that the committee should accept the school's voluntary plan to close, remaining open through November 15. And then Viviana, if you could just slide one more slide forward. There's an additional provision there that was requested during the Educational Standards Committee prep. The school has already agreed to provide an annual report for statistical purposes for the State Bar. And this is very little work for the school because it looks at the status of the school as of the 15th of September when they had few students, but it will complete our statistical profile. And so the committee members asked that were present at that meeting, asked that this be placed into the motion. So I would direct you to this version of the motion for consideration. And I do not believe that Dean Patel is here today. I'll just double check. I don't see him in the audience. If you are here, Dean Patel, please raise your hand. I'm seeing none. Just as a reminder, he is not required to attend. Thank you.
I'll make the motion to move. Having been on the committee, this particular school was very transparent about what they were doing, and also were timely in their providing materials to the
I'll
committee.
fill it when I'm there tomorrow and we'll check. Yeah, thank you, Vince, for the motion. Is there a second for the motion?
Second.
Thank you, Alex. Any discussion on this item from our committee? Okay, seeing none, may we get a roll call vote, Devin?
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Paul Kramer,
Yes.
Larry Kaplan,
Yes.
Alex Lawrence,
Yes.
Esther Lynn, Justice Macy Walla,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Dr. Cow.
Yes.
With 15 yeses and 0 nos, the motion passes.
Okay, thank you, Devin. Natalie, could you continue on the agenda item?
Certainly. The next item regards People's College of Law. This is a school that has been on probation since December 2022. Let's start with the motion. The school provides a progress report each month on the first of the month, and currently they're undergoing an inspection. The first day was this past Tuesday. The second day will be the upcoming Tuesday. We recently, in doing remote inspections, have set the days a few days apart to allow the school to gather any documents or address any questions from the team from the first day. You'll notice that the recommended motion here looks very similar, tracks the motion in August, and this was done on purpose. I want to clarify that that doesn't mean that there was no progress as to the specific items, but additional progress is needed. So referring to this motion, it asks for a couple of specific things. And in August, it was determined that there was at least one student for whom the school had no record of several of their courses. So the committee asked the school to do a transcript evaluation. The school did so promptly and reached out to alumni promptly, as well as current students. They did include an update as requested by the committee in their September progress report, but they were not able to find a large number of the students. They listed those students whose transcript needed to be changed, but the State Bar was CC'd on some of those letters and saw at least one student not on that list whose transcript required a change. And they indicated that for at least one class, they do not have a record of the attendees. Therefore, the school, I encourage you to challenge the school to complete that transcript review so that students can get accurate transcripts and full credit for all the study that they have done. And I think that that would be helpful. Second, it repeats the request for a motion to change administrative headquarters. This has been requested many times to the school. They have taken steps without committee approval. They have mentioned them verbally or provided at one point an incomplete motion to the committee after several requests from staff. But we do not have the complete details. What we can piece together is that the school has sold its building. It's in an escrow that must close by May. The committee has not been informed of the criteria that the school is using or the timeline that the school is using to choose a new location. And it is understood that the school has several pending expenses that require the sale of the building to cover those. So there is a concern about the financial viability of the school. So it's recommended that that remain. And then also because the inspection is in progress, it's recommended that this recommendation to cooperate with the inspection team remains. Other individual details are in the staff memorandum. There are a number of things that the State Bar has asked for before that the school has not provided or has not fully demonstrated compliance at this point. So that's the proposed recommendation. Jim, is there anything you would like to add before we recognize the interim dean? The current dean was placed herself on leave early in September. We're not sure of the length of the leave, and as of September 28, interim dean Ana Maria Lobos has been in service, and she's here today.
I have nothing more to add just yet.
Okay, I do see that the dean is here. So Viviana and Devin, could we recognize the dean for 5 minutes of public comment? She may share that with other team members if she wishes to do so. And this Ana Maria.
The dean just needs to unmute.
Good afternoon. Can everybody hear me?
Yes, thank you.
Hi, thank you so much. I know you've all had a long day already, and so I only keep you for a brief moment. I mainly just wanted to say that I am the new interim dean. My name's Ana Maria Lobos, and I am, as well as PCL, we are committed to continuing to cooperate with the committee in regards to all of its requests for information. There have been some outstanding items that have not been addressed fully, and we're committed to getting to the bottom of those and providing you with the requested information. I assure you that any questions as to why that information has not been provided simply go to a lack of organization in the school within the last year or so. And hopefully with me in charge, we can go ahead and provide you with all of the accurate information so you can make the appropriate decisions. And I greatly enjoyed meeting with the team last Tuesday, who did the inspection interviews with us. And I look forward to seeing you again next Tuesday. Thank you so much.
Thank you, Dean Lobos.
Jim, do you have anything to add?
No, we're in the middle of the inspection and we've made a bunch of requests and we'll see what we get on Tuesday.
Thank you. Are there any questions for Natalie and Jim?
Yeah, I do. Just one. Natalie, so for Dean Edith Pomposo, when is she returning from her leave? Do we know?
We don't know. She advised us the night before she took leave that she was doing so, and it was based on a lack of alignment between her professional goals and the school's goals. The school's council advised that they reached out to her and she did not respond. And we don't have further information except that they say that she is still the dean of the school.
Oh. Wow.
So would it be fair to assume that the position is vacant?
No, they say that she is in fact the dean and that Dean Lobos is in fact the interim dean. So it sounds as if they expect that she is still in employ and expected to return, but they do not have clear details as to when.
I mean, you can sort of understand the frustration that I have. I mean, we've been dealing with Dean Edith Pomposo for the last, countless months, years, and now we have a whole new interim dean, and I'm just very concerned that things are not where it's supposed to be when the school has promised us to meet certain objectives by now and in the near term.
And it may be helpful just for the new members joining today to understand that there has been quite a bit of turnover at the school over time. Dean Pomposo has been there since the end of last September, but since the school was inspected in 2020, there have been 5 different deans and there have been 5 different registrars during that time. So a key compliance element for the school is that their compliance practices and their standard procedures must take into account turnover because it is constant at the school.
Oh.
Any other questions or comments for Natalie or Jim before we put the motion back up? Okay. Can we put the motion up, Natalie?
Yes.
Thank you. Is there someone that is willing to make a motion on this item?
So Jim Afting will make the motion. And to answer people's questions, we will come back to the committee once the inspection is done to report what happened in the inspection.
This is
Thank you,
Vince.
Jim.
I'll second the motion.
Thank you, Vince. Any other further discussion or questions?
Thank you, Jim, for stepping up and jumping into there like that. I know it takes your time and your energy, so I just want to say thank you.
Thank you.
All right, Devin, can we call for a vote?
Dr. Bolton,
Yes.
Robert Brody,
Yes.
Alex Chan,
Yes.
Jim Efting,
Yes.
Kareem Gangora,
Yes.
Paul Kramer,
Yes.
Larry Kaplan,
Abstain.
Alex Lawrence,
Yes.
Esther Lynn, Judge Macy Walla,
Yes.
Bethany Peak,
Yes.
Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yochelson,
Yes.
Devin, I'm sorry. I'll continue. I have a question.
okay, Dr. Cal,
Yes. Alex, what?
Yeah, actually, I'm going to change my vote to abstain.
okay,
Devin, can you make that revision?
sure. Abstain. So with 13 yeses and 0 nos, the motion passes.
All right, thank you. We will move on to our next agenda item, the report from the director, Audrey.
Great. Tara, are you going to share that? You want me to share it?
If you don't mind.
Regina. Okay, I actually think the first thing might be Amy sharing the work plan, so maybe I should take this down. Is that right, Amy?
That's correct.
Okay, well, we're just gonna play up and down screens. We're gonna talk through briefly through the work plan.
Okay. Let me just pull up the work plan. All right, and for the benefit of our new members, let me just explain what the work plan is as well, while that's coming up. So the work plans, each of the sub-entities to the board are required to develop a work plan on an annual basis. And so this is the CBE work plan that we're going to walk through. Where the CBE plan is a little different is the CBE plan, most of the work plans align with the board's strategic plan. The CBE plan also includes work that is operational and business for the CBE. We used to have a group of goals that we had on an annual basis that we used to refer to as our CBE goals. So the work plan now reflects a combination of our goals and those goal initiatives related to the strategic plan. So let me share these and we'll walk through them. So give me 1 second. So what I've done is there we go. Let me know if you can see these.
It's up.
Okay, great. So based on the suggestions from the committee, I've highlighted the changes that we've made since the last CBE meeting. So this was attached to the agenda. And as you can see here, here are the updates since we last met. So for the moral character rules revisions, there is further revisions that are going to be circulated for a second round of public comment. And so in 2024, the plan is for them to go to the board. For business operations, there's a training and a presentation that's going to be coming up. In December, it's the lawyer assistance program. I've added a few items here that we talked about at the last meeting. These are under the examinations, and this includes considering eliminating the essay portion of the first year law student exam or revisiting the exam weights. That we did that today. Also considering conducting a standard setting study to determine whether the passing score for the first year law student exam should be raised or lowered. These suggestions were made at the last CBE meeting, so they've been incorporated here. And it sounds like based on today's discussion that these are should stay on here, and we will include these in our work plan. Next are these presentations. So we have one that's scheduled to happen in December. This is on substantive issues in evaluating TA request. In January, we should have one on the EDGE team on the basics of essay question development. And in March on the basics of performance test development. The next items that have changed are under the law office study. This is post the court's denial, the possibility of further revisions to the rules and circulation for a second round of public comment. Donna will speak a little bit more to that later. Also evaluating the phase out of handwriting options for non-TA applicants at the bar exam. It's a discussion that we can have and most likely we'll have in January. We also added pursuing the mandatory accreditation for unaccredited or registered law schools. We talked about that at the last meeting. So this is now explicitly out here because I think it was incorporated in one of the ed standards items. And then here's some of the items also that we completed. The input on the law school performance report.
Question.
Yes.
So the mandatory accreditation,
Mhm.
what do you mean by rules and guidelines approved by us? I don't recall us approving any rules or guidelines regarding the mandatory accreditation project.
Amy, would you like me to take that?
Oh, sure.
Sure. So Paul, this is referring back as a starting point to the committee and the Board of Trustees adopted regulations back in 2016. At that time, and still today, in order to go into effect, they would require a statutory change, and the statutory change did not happen. So if we were to bring back a discussion of mandatory accreditation now, we would start with that history. So it would have predated your time on the board.
Yeah, could you just send that to me when you get a chance?
Sure.
I think I should know about that as the new chair of the subcommittee.
Absolutely.
All right. All right, so then a review of the minimum MPR here was completed in August. And I think that's the last change that we have on here on the work plan. Any questions, concerns, or thoughts or additions that we need to make?
The couple we've identified today.
Oh, yes.
um,
You raised one on TA, reviewing the TA timelines.
Did
Right.
I?
That's what I made a note of. When we were talking about the testing accommodations, you said something that related to reviewing the testing accommodation timelines.
Oh, yeah, because that's something we required of you in a previous resolution. So that would be after 2 administrations. So yeah, if you put that in there, that's one.
Okay.
The one I had in mind was the other one was
Unaccredited rules, the unaccredited study, the time.
yeah, that's a second one. So but my first one was now the first year, now that we've eliminated the first year, maybe change this to reflect your obligation to come back to us.
Oh,
You
yes.
could just do that later. Yeah.
Okay, so adding the implementation plan.
Yeah.
Okay.
And then finally, I guess maybe it's appropriate to gauge whether there's any other interest besides myself. And again, my thought was right now our rules say that you have to complete a unit of law study. And by unit, I mean like a calendar period, 6 months or a year. You have to complete that within just a couple days less than a year, I think, 1 day less. And I'm wondering if we need to be that strict, if we shouldn't allow for people to do that work in a longer period than a year. You know, they would only get credit for a year's worth of work. But rather than have them lose all that work if they, you know, if they're a day late, so to speak, do we want to look into making that requirement more flexible? Am I the only person that thinks that that might be worth looking into? Or if so, I'll just say, don't worry about it. But if there's interest in doing that, then I'd like to see it on the list.
I say, don't worry about it.
Okay. Anyone else interested?
I don't know, it can't hurt to explore.
It is a resource issue though, so.
Yeah, I guess I should temper what I say with that. Resource wise, we have other fish to fry.
Yeah, and one of the reasons why it will take resources is because our rules are so complex and intertwined, and and the precision of their organization diminishes over time as we make one change here and one there. Making sure that we don't accidentally blow up some other requirement requires even more time than just simply stating what we mean to achieve today. So, okay, I will not worry about it on the basis of resources.
Okay, any other thoughts? All right, thank you.
I think what's nice to see too, Amy, now that you've had it all up, is how much was accomplished during 2023. Because when we meet back for the planning meeting in December, we'll obviously revise this and have some of our even more of these to carry over to 24 and other parts of the work plan for 24. But I think taking the second to notice how many things they completed for 2023 is impressive.
I second that. Did quite a lot of work for 2023.
You know what, if I could just say I'll just take a second to say to our new members, our new judge members, the director of admissions of the state bar was a lady named Gail for like 30 years. And when she left, we had the most amazing person take over, and that was Amy Nunez, who just spoke, who shepherded the bar through a complete change and first remote administration of the exam and got us through COVID. And she's since, moved on to other more specific projects. But Amy, you're awesome. And new judge members, wow, you have no idea how this individual took the bar through COVID and everything else. And, hats off to you, Amy.
Thanks, Robbie. All right.
Bolton wants to echo that. I agree with him 100%.
Absolutely.
Thank you.
Thank you so much for saying that, Robbie. And really, yes, Amy and the rest of the team, it's really a wonderful staff team, and it's great to always see the CBE and the new members too. So we have a couple more items to go over. Portfolio bar exam. Following discussion at COAF, and then you'll remember, well, not the new members, but everyone else will remember, we had a discussion here at the committee on the draft proposal. The Board of Trustees moved to send the proposal out for 30-day public comment, and that public comment period is open now. It closes on October 25th. The item will be back on the agenda at the November 16th and 17th Board of Trustees meeting. So this is the 2024 meeting schedule. So the December meeting isn't on here, but don't forget we have a meeting on December 2nd. That will be our last allowed all remote meeting. In January, we're going to meet as a full committee in person here in Los Angeles, and we'll give you obviously lots more details about that as it approaches. But we've sent this information out, but just to repeat it here in the meeting, the requirements for public meetings have changed for 2024 such that we need a quorum at one location for every meeting. So all of these, not the subcommittee meetings, all of the full CBE meetings, we're going to have a quorum in person at one location as required by the law. So we will, most likely that will be because of the Zoom enabled conference room that Dr. Cow and I are in here in Los Angeles. More likely than not, that location will be the Los Angeles office, but we might be able to look at other, we have used Loyola Law School, for example, for a meeting, so we can look at other locations. We have some time, especially for some of the meetings later in the year, to plan how we will facilitate logistically this change to have a quorum in person at every meeting. So obviously lots more to come about how we will do this, and it is going to be quite the change, especially for those of you who joined during the pandemic when we've been doing fully remote meetings like this one and the one in December. Oh, sorry,
Audrey?
Christina's telling me there's an amendment to,
Paul's got a question.
yes, but Christina has an amendment to this calendar, so I will change it real quick. Sorry. Christina, which one?
It is the second calibration is actually March 23rd, not the 16th.
Oh, so it's not by the meeting?
Correct.
Thank you.
And just to clarify, the December meeting will basically be like this meeting. It will not be in Los Angeles with everybody there.
That's right. Just with this change, it just seemed more prudent that we'll have the January meeting all in person, since we're going to have the requirement to have that quorum in person at one location for all meetings next year. So yes, January will be the full group here in Los Angeles.
And Audrey, has this gone out in a email or anything to the CBE? Because this is the first I'm seeing these dates.
And you know what? We might have just sent it to the new members, so we should probably send it's going to be posted obviously to the website as well. Devin, correct me if I'm wrong, if maybe we haven't sent it out to the full committee yet, but we send it out to the new members, so they'll tell you. Just kidding. We'll send it out to everyone and post it on the website.
Robbie, I do think it was attached to the email that had the survey for the subcommittee list, but I know it was missing the July TA subcommittee meeting.
I did.
So,
Okay,
yeah.
let me look again.
That's okay. We'll send a revised one anyway, because it looks like we had some of the meetings not correct on what we sent out, so we can send it out after this meeting.
And Audrey, if I could just do one clarification on in-person versus remote meetings. So what Audrey was referencing was a change in the law that's effective January 1 for a 2-year period, 3-year period, 2-year period, sorry, that requires, if we're going to continue having meetings by Zoom where members do not post on the agendas their address and have that address open to the public, then we have to have a quorum of the committee in person in a single location. If we were to continue the way we did for a few months this summer, listing everybody's addresses, then we can continue to do the meeting fully remote. So we do need to make a bar-wide decision on how we are going to be implementing this statute. And so I do want to just be on the lookout for communication from Devin on how we're going to implement this bar-wide. We do have to sort of consider resource issues, and there are going to be some logistical challenges just to make sure that you always have a quorum in person, because if we end up with somebody believing that they're going to be there and then something happens and they can't and we lose the quorum, then we basically lose the meeting. So we'll be issuing a bar-wide decision on how we'll be doing this. But what Audrey laid out is a likely possibility.
Thank you. And it is all, it is very recent, the changes, so you will have to bear with us. But I was going to mention something like the 1-hour subcommittee meetings we will do the address posting of accessible locations like we did before and briefly a few months ago. And there'll be more to come how we're going to manage logistically the rest of the calendar, but you can count on the January meeting being everyone in person. Alan Yokelson?
The January 26th meeting, is that a one-day meeting?
Yes, there's no.
It's
no
only on
selection.
Friday. It's
Yes.
only on Friday.
That's
Okay.
right.
Thank you.
Audrey, we should also mention that in December, on the Saturday, there's a questions selection meeting at which the attorney members need to be present.
Yes, thank you. The final meeting that is going to be all remote in December. The Friday will be the regular committee meeting. The 2nd and December 3rd for attorney members who are not recused for any reason will participate in question selection for the bar exam.
I'm sorry. Is question selection in person or is that also virtual?
It's all going to be remote.
It is going to be.
Remote.
Use a
Okay.
secure,
Remote.
Zoom.
Yeah.
Yes, remote.
Okay.
Amy?
All right. So speaking of the first year exam, so the October 2023 first year law student exam is scheduled for October 24th. It's the same day as the legal specialization exam. So we have about 214 applicants that have been approved to sit for the exam. And just to give you a sense of what that represents compared to previous years, in 2022, we had, for October, we had 25% less, more people. So we had 284 in 2022, and in October 2021, we had 322 approved applicants. So our numbers are declining for the first year law student exam in general. One change that has been made with this administration, as we've noted, this is going to be our 7th administration that we've done remotely. But this one this administration is primarily an in-person administration, meaning that applicants have been directed to take the exam at a Prometric test center. And these are test centers that are located at multiple locations in California. There are more locations than we've offered in the past. So you can find them in Fresno, all over the state. And there are some sites outside of the state. As a matter of fact, we have one person who's going to be testing in Florida. The reason that we went to an in-person Prometric test sites method is it was in response to technical issues that applicants reported having in June. As you may recall, we had about 23 students out of the 226 that took the exam that were unable to complete the test because of technical issues. So as a result, we're trying to use these Prometric test centers. We have about 158 applicants who are scheduled right now to take it at a Prometric test center, and 55 who have opted to test remotely. And they've opted because they either live too far from a Prometric test center or had other reasons that compelled them to want to test remotely. And so that is where we're at with the first year law student exam. I'm also going to talk about the pilot for the California bar exam experiment. And for the new members, I want to give you a little bit of background. So you know that, or if you don't, the California Supreme Court and the Board of Trustees established the joint Blue Ribbon Commission on the future of the California bar exam to explore what the future of the bar exam will be in California. And that commission started the exploration in 2021 and submitted their final set of recommendations in May of this year. And the commission recommended to develop a California bar exam after exploring other options, such as whether to adopt the reformulated national exam, the next gen exam. The commission also recommended to adopt the skills and areas that were recommended from the California-based attorney practice analysis, that they should be incorporated in the new California bar exam. And so all of these recommendations are going to require a redesign of the bar exam. And in anticipation of that redesign, the state bar has started exploring other exam features that should be considered in the future bar exam. And this includes exam modality, like remote versus in-person, open book options, and exam timing. And so the state bar applied and has been awarded a grant by Access Selects to explore these exam features. And specifically, what we're doing is we're investigating whether exam time allocated to each item, whether remote versus in-person administration, and open book versus closed book affects test takers differently. What we want to be able to know is, for example, whether students of color fare differently in an open book environment compared to the rest of examinees, or to know whether more time on essays impacts performance. So with the help of an advisory group that includes 2 members of the CBE and representatives from accredited and registered law schools, we've executed a plan that involves conducting a pilot and an actual experimental exam. And so right now the pilot is scheduled for Saturday, October 21st. We have a total of 442 study participants that are scheduled to take the pilot. For this pilot, we're going to be testing timing. So some participants are going to be getting the standard time, and others will be getting extra time. And we're going to be testing three different formats of open book. So some people will be getting closed book. Others will be getting will have the ability to bring in study notes, like hard copy notes. Some will have access to Westlaw, and others will have what we're calling open book, open web. And the one thing that's restricted under open book, open web is AI and chatting capacity. So all of the applicants in the experiment are testing remotely just for the pilot. For the actual experiment, we'll be testing both remote and in person. The incentives include, obviously, performance feedback. All of the applicants will get feedback on their performance, letting them know how they fared compared to each other. And they're also going to receive a $50 as part of that incentive. The top 3 performers will also be getting $200 each. Participants are coming from all California law school types. So we have school representatives from ABA, registered and accredited law schools. And it's taking place, like I said, on Saturday, the 21st. They start at 10 a.m. And we are very excited about this event. And we plan on reporting back to this team with results after that.
So, Amy, all of the participants are current law students?
They are. They're most of them are 3Ls. There might be a few 2Ls in the group, but we are targeting 3L students.
Are you using essay questions or multiple choice, or?
Yes, we're using essays and multiple choice.
And are the essays from our bank?
They are.
How about the multiple choice? Are they from prior MBE?
They're
MBE like multiple choice
MBE
questions.
Wow. Oh my gosh.
Yes.
Huh. That's unbelievable. And I want to say to the group, Dr. Cow and I visited a Prometric test center when we were doing the research, and I think some members were asked to visit centers and report back, and it's awesome. It is totally awesome. So is this the first time we're using Prometric?
Oh, no, we've been using Prometric.
Oh, okay.
Yeah.
It's the first time that the majority of the applicants are testing at their test centers. We've been using them for their live remote proctoring.
Remember, Dr. Cow, we went to the one in Glendale?
It was a phenomenal site. They did a extremely professional job. I wholeheartedly agree with you, Robbie.
Didn't they accuse you of cheating though, Dr. Cow?
Well, if I would have got 100% looking at your exam, I would have been cheating, but because I couldn't, who knows, right?
All right.
Thanks, Amy.
Sure.
Thanks, Amy.
Thank you.
Tara?
Yep. As you may be aware, the admissions fees went to the Board of Trustees at their September meeting. And so they were approved with the exception of the California accredited law schools. Those are going to go back out for public comment later this month with the tiered approach. The general direction from the board was just adjusted downward. So the proposal will have a few options for the public to weigh in on. So the other fees will go into effect January 1st. The bar exam fee is actually already in the application right now. And then the out-of-state attorney arbitration council, trying not to use the acronyms, and Pro Hoc Vice, both of those are also tied to a California rule of court. So those will also have to be amended as well before we can start charging those fees. But the other fees, which you'll see in a moment, will go into effect at the beginning of the year. So here we do have the current fees, when the last increase was, and what the new fees that the board approved and the increase. For those that are just joining us, so the bar exam previously had the split general applicant and attorney applicant fees. We did mirror that for the moral character application and the extension application. So you'll see that now that was not something that was there before. And thank you. And here you'll see that the fees for the registered house counsel under the multi-jurisdictional practice program, those fees have increased. And the fees for the legal aid attorney and military spouse attorney decreased by a bit, just to be in line with the state bar goals of access and inclusion. And the middle section of the two fees that are tied to the rules of court. Sorry, Audrey. And you can go to the next one. That's fine. Thank you. And these were the approved fees for the registered unaccredited schools.
Sarah, what was the board's concern about the fee increase for the accredited law schools?
Tara, do you want me to take that?
Yes, please.
So the fee increase for the accredited law schools was significant. It's a fee increase for the annual report of 955%. We created a tiered, some options for the board's consideration of how they might tier the increase. So the smaller schools would not have to pay the same amount that the larger schools would be, understanding that the schools have informed us that they have no option but to pass the fees along to the students. And so we wanted to create some tiers, the way that the fees are, same way the fees are applied to the unaccredited schools. So we created the tiered structure as well as an option that would just take the whole amount that we expected to receive, divide it across the number of students that were enrolled as of the 2022 annual report, and say a school pays $90 per student. The board appreciated the options. I think especially the final option of doing it at the per student rate, but they were certainly aware of the concerns from the CALs. Also, they were pleased to hear that revenue was coming in $2 million higher than projected. And so we had a little bit of room. And they were aware that the tiered structure for the fees for the CALs was the one thing that hadn't gone out for public comment. So with those pieces together, the board directed that we send the amount for the CALs, the tiered structure for the CALs out for public comment, but that we do a downward adjustment because of the extreme increase at 955%.
Thanks, Don. I mean, even for accredited law schools, I mean, the increase here is pretty significant, but somehow the board of trustees didn't express any concerns about those increases.
So the fee increase for the annual report for the unaccredited law schools is just shy of 600%. And so that was certainly one of the options that I had presented to the board. Hearing their concerns was, well, we could just lower the amount that was projected for the CALs from 955% to the same 588%. That would be more like $58 per student as opposed to $90 per student. But they really were interested in getting some public comment and seeing what that comment would be on the tiered structure.
Thanks, Donna. Very helpful.
Does their goal appear still to be able to fully recover the costs? I think because of the decisions that have been made in other places, it wouldn't be for the law school regulation function by itself, but for the whole program.
Yes. So the proposal that went to the board, which included the fee increases for the CALs, brought us it was 7.9 million of fee increase projected revenue from the fee increases, as against expenditures of a structural deficit of $8.4 million. So coming super close to closing that gap at $500,000. Again, and then that $500,000 was covered by the projections related to the change in the structure of the February 2024 bar exam being at those 6 sites. So that basically brought it to even. And again, they felt that there was a little bit of room to move because we came in for 2023 at about $2 million higher in revenue than projected. We don't know if that was a one-time event or if we'll see continued revenue to continue at that level. So that will give us some insight for future years on what we need to do in order to continue to break even and have the money that we need for things like developing a new bar exam.
And maybe an alternative to the bar exam. Yeah. Seeing this, these numbers flashed on the screen so quickly makes it hard to absorb them. So I wonder if you can't share at least these slides with us, so we can peruse them at our leisure.
Yeah, they were all, I think Tara took them right from the posted board item from the September board meeting. Is that right, Tara?
That is, yeah.
So we can link everyone to that board agenda item.
Okay. Yeah, I tend to go of late. I've been looking at the board recordings and pulling down some of their materials. But I don't know that all of our members should be expected to do.
Yeah, no, we can link
amount
to
of
that with when we send out the revised dates, we can link to this agenda item so everyone can see these numbers.
Okay. Thanks.
No worries. Next up is Cody Hunanian, who I don't know, I should probably introduce him before he speaks, is our new program director for policy data and AIMS being what we call the database that we use in admissions. So he joined us, I'm going to say 6 weeks ago, that could be right, very recently. This is his first meeting. So take it away, Cody.
Thank you so much, Audrey. I am new, so I'm a fresh face, but I'm hoping one day I'll get one of those glowing reviews from Robbie that Amy got. That was very kind. So for new members, in June, the committee recommended that the State Bar transition to a one-day remote exam in February of 2024. We determined that it would be best to kind of assess its feasibility, particularly in terms of exam security and accommodations for applicants with special testing needs with this remote setting. So we are currently looking into this, and the hope for us is to make a decision for the July test. And here's what we're doing. And when I say this is really a kind of an Office of Admissions wide initiative because there are a great deal of questions for us to address. So I think some top lines include, first, we are studying data from post-exam surveys and exam outcomes during and after the pandemic to give us the necessary confidence that a remote exam does not result in lower scores for everyone or for any particular population group. We are also engaging with other jurisdictions across the country and remote proctoring experts to identify new approaches, new technologies that would make it possible to administer a remote exam in a secure manner. We're also identifying the best ways to support those testing accommodation requests that I mentioned, with a focus really on the accommodations which in the past did not lend themselves to a remote setting. A few examples would be how do we provide physical exam materials? How do we include personal assistants like typists in a remote exam setting? So this includes some exploration we're in the process of regarding novel proctoring methods. Again, that's the secure delivery of exam materials. What does that look like? And really, we've been reviewing kind of our internal processes to identify improvements to our communication strategy and our testing accommodations applications process to fully support a remote exam setting. We are also researching the opportunity to create multiple choice questions distinct from the MBE. This would allow the State Bar to administer the entire exam remotely. And just an important note throughout this process, we have been consulting our psychometricians, some of which we've heard from today, to uphold the State Bar's high standards of exam validity and reliability. And of course, we are working very closely with legal counsel on all relevant issues.
Thanks, Cody. Okay, I think it's back to Tara.
So as Cody just mentioned, we are looking into testing accommodations for a remote or hybrid remote exam. So we do have a stakeholder forum that's coming up on November 3rd. Devin was kind enough to get that posted for us today. So the agenda is up and there's a short attachment that explains the purpose if you're interested. Just as way of background for those who are new, during the pandemic, there were certain testing accommodations that we weren't able to administer remotely without compromising the security or validity of the exam. So those are the ones specifically that the forum is going to be focusing on. And one of our colleagues, Elizabeth Hom, who's one of the program directors for the Office of Access and Inclusion, has been kind enough to agree to facilitate the forum for us. So more to come on that.
Thank you. Donna.
Yes, thank you. As many of you know, the first sets of rules that we were able to, that we developed and went out to public comment were adopted by the board and were submitted to the Supreme Court for approval, was a combined set of rules on the practical training of law students in the law office study program, as those were interrelated, and a set of rule changes on the moral character rules. The Supreme Court, unfortunately, denied our proposed rule sets and sent those back to us. They did send them back with a helpful letter explaining the issues that they had, and we are currently working on some changes, and we'll be bringing those rules to you. The moral character rule proposal, the issues were largely technical, but it does give us an opportunity to package the major moral character rules that we had already submitted, as well as the follow-on change that we did that this committee has approved regarding 4.41 and the ability for out-of-state attorneys who are suspended or disbarred in their other jurisdiction to submit a moral character application. Under the current rules, as you may recall, they can't, and we were changing that rule to give them the ability to apply, but creating some more stringent review of their application. Because the moral character packet was sent back by the court, it will give us the opportunity to roll these all together, which makes a lot more sense overall, since we've now got the time to do that. On the law office study and practical training of law students, the committee members will recall that a key reason, or that one thing that we were looking at on the practical training of law students program was whether we should change it to allow law office study students to participate. This committee said, yes, we should allow law office study students to participate and change the rules accordingly. The court was thinking about the scenario where somebody is studying in a judge's chambers, so studying with a judge who is their supervisor, and then becomes a participant in the PTLS program and is has a case in the same court where the judge that they are being supervised by in the law office study program is a judge. And so they wanted us to think about how to deal with that situation, right? Which could be done in a number of ways. Prevent those who are studying in a judge's chambers from participating in the practical training of law students program. We could say, if you are studying in a judge's chambers, you just can't, if you participate in PTLS, you can't do it in a court in the jurisdiction where you're studying. But the court very much wanted us to think about it and give them a proposal for how to address that. We have looked, and currently, and we're doing a further look back, but currently there, of the 134 or so students in the law office study program, only one of them is studying with a judge. We don't expect the numbers to be much bigger over the last 5 years. And so the participation rate in studying with a judge will go into the recommendation that we present to the committee to revise those rule changes. We'll send out whatever change we make there. We'll send that out for public comment and then package that back up with the rest of the PTLS and law office study rules and send that back to the Supreme Court. So just one of the things that Audrey and I will be talking about is a careful sequencing of all of the remaining rule packages. And so we'll be bringing that back to you. Maybe I'd like to do that in December when you're going to have your planning session. Just have us sort of give you a recommendation for how we will sort of roll out the remainder of the rule changes so that we are certain we've got sufficient time to think through all of these issues, packages everything up in the right order and get them to the court in the best shape possible.
Thank you, Donna. Oops. At the end, other ways to develop. There was only just one thing I was remiss in mentioning about next year's meetings. Let me exit out of this. So we have the ability to have hybrid, right? So even if we have the quorum in person, it'll be a hybrid meeting when some of the members are on Zoom or whatever our platform will be next year, assumedly Zoom. But there is a requirement starting next year that cameras would need to be on for all members. So, and I know sometimes there's a reason, of course, why you turn your camera off, but just to give you a highlight that there is going to be, absent a technical problem, the expectation that the members will have their cameras on during the public meetings. And that's all for the director's report. And did you want to take a 5-minute?
Yeah, so thank you so much, Audrey. So two things I want to bring up. I think we should take a 5-minute break, but I just wanted to let everyone know that we are done with the open session. So when we come back in, everyone should come back in and join the closed session that Audrey had sent an email for the closed session, October 14th, 2023. So, October 13th, I'm sorry. Yeah, October 13th. So right now it looks like it's 3:05. So when we come back at 3:10, let's come back in the closed session. Thank you.
Well, they're coming in.
Yeah, they're coming in. All right, looks like, all right, so we finished the meeting business has concluded. Is there any more business that anybody would like to bring up? If not, I would like to adjourn this meeting in the memory of Judge Herman, and we will see everyone in December for our next meeting. Thank you so much. Have a great day, everybody.
Thank you, Mr. Chair.
Thank you.